All right, thank you. So welcome everybody to today's meeting of the Bench Bar Foreclosure Committee. I will first just call the meeting to order, and Becky, if you want to note those present for the record.
Absolutely. We have Judge Baio as chair, in no particular order. Judge Aldermatt, Judge Spader, Attorney Pocklington, Attorney Douglas, Attorney Generis, Attorney Gentis, Attorney Claxton, and Attorney Salato, and Attorney Schmidt.
All right, thank you. And welcome to our two new members. We have two mediators joining us. So Tej and Travis, welcome aboard. We're excited to have you as part of our committee. And for those of you that don't know them, they are foreclosure mediators. You folks, either of you want to say anything? No?
Thank you, Your Honor. Nastasia Douglas, mediator since the inception of the program. Excited to work with you all. So very happy to be here. Thank you.
All right.
And hello, Your Honor. Again, I'm Travis, and I'll probably ask a lot of questions while my mic is on mute, but I'll actively listen even more. So thank you for having me here today.
All right. And I would note, I think, Becky, I think that at least the one I have, the agenda inadvertently indicates April 30th as the date. So but it's for today's meeting.
Correct. And I think it was updated on the website, Your Honor.
Okay, perfect. All right. So if you have an agenda dated April 30th, it is indeed the agenda for today. Before I get into the resignation, we'll do that under new business only because it's not currently an agenda item. So the first item after the call to order is approval of the minutes of the April 30th meeting. You should have all received a copy of those from Becky. Thank you, Judge Spader. I almost called you Attorney Spader. And is there a second?
Seconded.
Yep.
Attorney Generis. Any discussion? All those in favor?
Aye. Aye.
Aye. Any abstentions? Any negative? All right, then the motion carries. Under our old business, we have on there, and I know that I was unable to make it to the last meeting due to scheduling issues, so I did review the minutes, I did speak with Becky, and I do have the update, and I thank you folks for proceeding. With regard to the timing of the supplemental judgment, that has been accomplished. I think, Becky, you have an update for us on that, right? The notice. You're muted, Becky.
Thank you. The timing of the supplemental judgment, the JDCV 79, was updated and posted and shared with all the clerk's offices. I believe that Judge Bellis also shared it with the judges.
All right, excellent. And then the other issue under outstanding recommendations was the issue of signs at the property, and that recommendation was passed on and was pending review. And Becky, you have to share with us a recently received input with regard to where things stand on that, if you could share that with the group.
Thank you, Your Honor. There was just some follow-up questions for clarification, and because they weren't posed ahead of time, if you want to take them back and think about them and then email me anything, that would be great. The first question was, do other states require signs? If we know whether or not what the sign requirements would be, if any, for other states. And then as far as the non-appearing party recommendation, the portion of our recommendation was that the sign remain a requirement for non-appearing defendants, and appearing defendants could opt out. So for those non-appearing defendants where the concern was notice over the embarrassment of having a sign, just some more information regarding be helpful from the mediator standpoint as well as judges and practitioner standpoint. How frequently does that occur where a non-appearing defendant is receiving notice for the first time via the sign being posted at the property? Anecdotally, if you know what the circumstances are, I think we've all probably had something happen where, the spouse didn't know or what have you. So just kind of looking for some feedback as far as why that concern, the frequency of when it happens and how does it happen. And kind of a smaller follow-up question from that would be if you, within that concern for non-appearing defendants, is there something else that's being missed beyond the sign being posted that is causing the sign to be the first time that somebody knows? So I think we've all had those, it got stuffed in the side door for abode service and things like that. So any feedback you have on that, if you could just email me that, and I'll put them all together in a summary and send it to Judge Bayo for her review.
So just to give the new folks some background for where this comes from, as you saw in the minutes, if you had a chance to look at them, and if not, you can take a look. A suggestion was raised to address the issue of signs being posted on the property, and the recommendation ultimately crystallized into a recommendation that the signs should that appearing parties can opt out of having the sign there because of important considerations that were raised by members of the committee. I know Judge Spader raised one, which I share, which is that sometimes the sign is the first notice that a non-appearing party has that they've been foreclosed on for a variety of reasons, as Becky indicated. Some of them, sometimes there's a divorce situation or people in the house together where one person may get the documentation and not share it with the other. There may be other considerations. I know we all probably have a variety of them, but these were concerns and just again, so the new folks know, we are an advisory committee. I think you know that, but when the body of this board comes up with a suggestion, then it comes through Becky and I, we send it to Judge Bellis for review and get her feedback, and she'll either, if she is on board with it, then we get authorization to send it up for recommendation to the Chief Court Administrator's office. If she is not on board with it, we generally don't send it up to the Chief Court Administrator's office because the odds of it making sense to do that are not great. In this instance, we did make the recommendation to Judge Bellis, and these were some of the questions that she had. Becky and I were trying to figure out the best way to address it because it sounded like she wanted some, I'll say documentation for lack of a better description, but as Becky said, it could be anecdotal too. But to the extent you have any input, rather than brainstorming it today, because I want to give you time to think about it, think if there are things that come up to you that you think fall within the category of answering these questions. And Becky will take care of collecting that information. She'll share it with me. We will try to synthesize it into a summary so that we can share it with this group and make sure that it fairly reflects at least the key issues. And then we will send that off to Judge Bellis for review. Does that make sense to everybody? Anyone have any input?
Just a thought, and I'll throw it out there because when do I ever shut up? It may be worth just a quick suggestion.
James, I think you just froze.
The internet shut him off.
By the judges to your.
Wait, James, you just froze.
Oh. I can hear you. Can you not hear me?
We can hear you now, but when you were speaking, why don't you start over?
Just a thought is, because we have so much time between our meetings, it may be worthwhile to suggest that, and this could certainly be done by the practitioners, but the judges may have better access to information, to just sort of keep an eye on the number of motions to open that they're seeing filed at or around the time that the sign is first placed on the property. It may be, or the mention that I didn't know about the foreclosure, but it was after the sign was placed and that type of thing, just to get some slightly more empirical and less anecdotal data.
That's a great suggestion. Anyone else have any thoughts on that? All right. And certainly with regard to what other states don't require signs, I think it was Attorney Gentis who, or maybe I'm mistaken, but I thought it was Attorney Gentis who mentioned to us one of the states, and Becky and I were trying to remember and seemed to think it might have been Vermont.
That's the only state that also conducts sales at the property.
Okay.
There's
So
none,
if you guys,
none
go
else
ahead.
that we know of that post signs on the property.
All right. So this will give a little time for, if you are inclined to do so, if you know, or if you want to look into it to determine whether there are, whether that's true, whether Connecticut is an outlier in that respect. That information would be helpful for us to put together. And then we can also, once we have, I don't want people to feel inundated with tasks, but so I don't want to give an artificially short amount of time, but as James pointed out, we don't meet for a while. So I want to give you enough time to consider that. You're certainly free to send whatever information you have to Becky before that. But if I said within 30 days, does that sound okay? Too long, too short? I got a thumbs up from James. I got a few more thumbs up. All right. I think we have general consensus then. So within 30 days, and that way we can get a sense of what information we have. We'll try to get that synthesized and circulated so that we can hopefully make some progress with regard to that recommendation. And then anything else on the sign issue? That's all I had. Okay. The next issue was which dovetailed with this, the holding of sales at the property. And Becky, when we spoke, you had a report on that? I know we had concerns about there were certain issues that were raised as concerns to that.
I don't think I have a report. I think that we I don't know that we reached consensus at the last meeting, Your Honor. So I think further discussion was to be had today regarding that. I don't know if you want a background for our newer members on that.
Why don't you? Yeah, sure.
Yeah. So the issue is, as Attorney Gentis mentioned, Connecticut holds sales at the property. Vermont, I think you said curbside, Attorney Gentis, and that other states do sales at the courthouse, and whether or not that would be something that we could recommend for Connecticut, with the understanding that whatever recommendation comes out of this committee regarding the issues that may arise out of that would obviously go to other levels of judicial court operations, Chief Court Administrator's Office, and probably legal if there were any. We did discuss some of the aspects where there might be some liability for holding judicial sales on judicial property over the weekend. That would be beyond the scope of the committee. So the committee scope is just whether or not we wanted to make a recommendation regarding sales. And I don't believe that there's anything. The last couple of times the committee met and discussed this, there's nothing really in our regulations or in our practice book that requires that. I think that the sale procedure itself came largely out of prior committee meetings of this committee, 15 years ago. There were a larger group and subcommittees tasked with kind of putting that all down on paper, and the JDCP 79 that you're all familiar with, as well as the 81. So that's where we are, with no real consensus on that topic at this time.
Thank you. And that's right. I do see that it was tabled until today. And there were some issues, legitimate issues raised with regard to, well, as Becky mentioned, one of it is, again, similar to some of the foreclosure judges received request for input into a recommendation that was made not through this committee, but through a group of attorneys who had sent in a request relating to having sales on days other than Saturday. And so that's something that, again, was sent directly to administration, but as I would expect would happen, even if Judge Bellis were to consider whatever approval we put in, she would most likely reach out to the judges who are most involved with foreclosure just to get input. But I know that there were, in my absence, but in reading the minutes, I see them as legitimate issues. There was concern not just that this would maybe something beyond the scope of this committee. Certainly recommendation isn't, but beyond that, we don't implement, we just recommend. But issues of liability, in particular, if there's a suggestion of having to hold it at, I think one of the prior recommendations, and I don't know if it was raised at the last meeting, was holding it at the courthouse or that kind of thing. And so there's issues of logistics, there's issues of liability that would need to be considered. We can certainly open up the discussion. I do just want to mention, though, related to the issue of sales, not at the property, but the day of sales. And I think most people here are probably aware of it, but Becky, did that become official yet? The issue of the potential Fridays?
No, I don't believe so.
So am I at liberty to discuss that?
It was the issue was sent back to the group that proposed it with the mechanism for where it needs to go to be.
All right.
vetted.
So then I'll just leave it at that. There was an issue raised about whether there could be sales on a day other than Saturday, and that is being addressed elsewhere and not through this committee. But as far as the issue of holding the sales, whether sales should continue to be held at the property or whether there should be some alternative to that, I know it's been discussed a few meetings. I was here for the prior ones, but not the last meeting, and I know that it was tabled until today. And as Becky noted, if we do make a recommendation, and I don't know if we're at that point yet, I'm going to open it up to hear from you. But even if we were, it would be something that would be vetted through several other layers beyond us because of the significant issues associated with it. So I open it up for discussion, folks. Nobody?
I suspect that Attorney Generous and I probably have the least to say on the subject because with our primarily plaintiff portfolios, we're generally just electronically submitting the opening bid and not physically attending. But what I would point out is that one of the advantages that I don't think has been discussed in the past and that sort of occurred to me after our last meeting is the way our judicial districts are set up. If we were looking, committees are appointed from within the district, and many clerks and judges that appoint committees do take a look at the actual towns, especially in the more geographically spread out districts. Hartford's fairly compact compared to Putnam, et cetera. I would be concerned about the geographical imposition if, for example, if we were calling sales from the courthouse steps down in Stamford, that's potentially a long drive for a lot of people that would be potentially bidding on a property in their town, even if you just think about, the nearby districts. And that's not even the worst in the state when you consider how far people have to. I kind of wish Judge Rohrbach was here because he knows the Litchfield geography better than most, but getting to the Litchfield courthouse compared to some of the smaller, areas that may have a sale, keeping the sales at the subject properties could prevent a geographic impact that could disproportionately have a chilling effect on the numbers at sale. And the other thing that I would mention, just because I have sourced this around to some peers that work in other states, the whole calling the sales on the courthouse steps that works in larger non-judicial states like Texas and whatnot, which is where I think the term originated. The trustees that are appointed tend to all show up with a large number of files, not individual appointments. So the Connecticut system of individually appointing a committee for one sale on a particular day could mean that we'd have many committees trying to do a bunch at the same time at the same place, whereas in other states, particularly non-judicial ones, there are fewer trustees, fewer individuals physically there for that purpose. So it may, if we were to consolidate or recommend consolidating geographically, it'd have a lot of ripple effects on how committees get appointed, how they do their work, et cetera. And I'm not sure that's a can of worms that, at least from my perspective, is broken enough to need a fix.
All right, thank you for that. All valid points. Anyone else want to be heard?
If I could, Judge Bale.
Sure.
I think it's just in terms just to other states, there's a variety of approaches. You have like courthouse steps, that's, New York and a bunch of others, or you have like county or, other government buildings. At least Ohio is now doing this all online. So it's essential. And then others are just like a public place. So anywhere that's accessible. I had flagged, liability as like, I'm sure someone will come up with this as a potential downside. I don't know that the current system is like liability free, right? If judicial is telling people go to this person's private property that we haven't inspected and we don't know what's going on, and go to a place where there could be an agitated homeowner sitting there, that doesn't seem like, risk free right now. And I don't mean this, oh, well, there's already homeowners insurance. I mean, there's just we already, there's always, there's cases enough around like evictions gone wrong or people who've been evicted, countersuing and the like. So I think there's still like liability under the status quo that, this may just be a shift to a place that already kind of knows how to handle, hundreds of visitors a day. The part on the, I understand the distance to the courthouse. To me, I just feel like if someone's making a 6-figure purchase and, they're making like, they're bringing like 30, 40 grand to the table that day, that driving, a half hour, 45 minutes instead of 10 is probably not the barrier. In this instance that, transportation might present in other kinds of situations. I think in terms of the committee point, you either do it through multiple committees, or you just have like a committee, or you actually have somebody else handling. You could either have one committee handling all the sales that day, or you could have, committees take their turn. Whoever actually has a sale that day. I mean, if you kind of break it down by how many there are, I mean, we may need to either think about having like a committee handling multiple sales on a single day, or just fewer committees, because it would be, having 15 committees handling an auction on a courthouse might be kind of chaotic for the day. At the same time, it might bring more winning bids if it's a matter of like, I know I could get some kind of property by showing up this day. And it's more efficient rather than having to drive to each property at noon. I can't be all those places at once, but now I can come here and there's multiple properties up. Might be a good thing.
Right. Anyone else?
My biggest concern is something that James mentioned. As far as, I don't know what the standard practice is for most courts, but generally when we have a foreclosure short calendar, on a given date, the same sale date is used for every file, which obviously is the issue that James brought up with respect to multiple different sales happening at the same time. But my other concern would be for files where there's motions to open, the sale days extended, added on to a date where there are already multiple other sales taking place. And there's never going to be the same committee appointed for that file versus all the other files that happen in short calendar. So I think just a general scheduling issue might come up with regards to that, based on the fact that you'd have 15 different sales happening on the same day, and then potentially more being added on based on motions to open. The committees will all be different. I personally find it slightly concerning to have one committee handling all of the sales for one given day, based on the fact that we already have issues with a committee just handling one sale for a given day. So if someone has 15 different sales scheduled for a day, I don't think that's going to go very well. But that's just my general concern, is that the logistics of it seem like they would be very difficult to work out.
All right. Anyone else?
all that said, I mean, we can figure out logistics. I kind of agree with a lot of what Attorney Gentis pointed out here. A lot of those concerns are real concerns. If it came down to the point of figuring out logistics, we could figure out logistics. I just don't know where we're going to be at as a committee as far as a recommendation in the future. But I think the logistics, if that was the one blocking point, we could figure that part out.
Right. Travis, it looked like you were going to say something.
No, I wasn't going to say anything.
Oh, all right. Judge Altermat, were you leaning
It's
in?
a very casual poll of some of the practitioners up here who are often committee for sale, and their initial response was, "No, it works. Why change it?" But then, of course, they got intrigued and they said, "Well, what would the alternative be?" And I said, "Well, I don't know. I'm just wondering if from a practitioner's point of view, if you saw any issue." And at least one said, "I think it actually helps for people to see the house one last time or see the property." And they also come away with an impression of the person living there, whether it's going to be a forced eviction or whether the person is, the practitioners seem to think it didn't hurt to be there that morning or that afternoon. But again, they, like the rest of us, were interested. Well, tell me what the alternative would be, and we'll certainly be amenable to it. I would say in some of the smaller courts, I can say for this one in particular, trying to do it in the courthouse steps, or even trying to find a courtroom in Putnam to do these things, even if it's only once or twice a month, it would be a real nuisance. And I don't know whether we're going to put support enforcement out in the parking lot, or put family relations out in the parking lot, or put me out in the parking lot, but somebody would have to give up a courtroom, so that wouldn't go over too well on most days. But then again, I realize we have much fewer resources than most of the big courts, so that's just a personal perspective, I suppose.
To that point, and I know I'm not alone, at least I have Judge Altermat with me on this one, but I don't see the courthouse being a realistic alternative or something that would come out of this committee for a lot of the reasons that he mentioned, but also doing something like that inside the courthouse. I think it raises a whole bunch of other issues, including the HR, the liability, the work and contracts of the various employees that are at the courthouse, and even doing it after hours at the courthouse. There's liability concerns. There's potentially overtime concerns if the court feels the need to have marshals there. I just don't know. This is just me talking. This is just my opinion. I just don't know if that is a realistic alternative. I understand that sometimes change is hard, and so it's hard to wrap your head around new ideas when something has been going a certain way and seems to be working. But there's a lot of considerations on both sides. Judge Altermat raised, I think, also a legitimate thought, which I hadn't thought of until you said it, and it makes perfect sense that a lot of times the potential buyers, they want to see what they're getting themselves into, or what they're having an opportunity to see it. So that would weigh on the other side. So there's pros and cons, and I guess the question at this point is, what does the committee want to do? Do you want to explore this further and come up with some sort of a proposal? Do you want to leave it alone and leave it tabled for now until until there's some desire to make a recommendation? Do people want to make a recommendation or not? Tell me, folks, what are you thinking that we should be doing with this particular issue?
If I may, one thing that sort of just clicked, and I'm sorry that it didn't crystallize earlier, and I'll answer the question you just asked, but just a thought for all of us to the back of our mind. One of the things that the appellate court has consistently said needs to be taken into account with motions to approve a sale is irregularities at the sale. That's why the form asks about the weather and things along those lines. If we were to go to a mass sale model and have one of those horror stories that we've all experienced, there, thank God they're few and far between, where a crazy borrower disrupts the sale, does that mean that all of the sales in a given block were somehow tainted and would have approval issues? And there's actually potential legal concerns. But having said that, to answer the question that you asked, Your Honor, I view this as a tableable thing. It's not a fear of change. It's a what we've got works, and I haven't heard anything compelling to change it yet. I'm not saying that there isn't something compelling out there, but I don't think that this is a location of sales. There's so many worms in that can that it's, and no reason I can see to open it, in my opinion.
All right, thank you. Anyone
I would
else?
table it.
Who
I just
said
realized.
that?
Oh no, sorry.
I'm sorry, I don't know who was, I'm not sure whose voice popped up first. I heard somebody say they would table it. Who said that? That was James. Okay. And then Attorney Altermat, were you going to say something? And I know Attorney Gentis was going to say something. I'm just not sure who was first.
Yeah, I think Attorney Pocklington said pretty much where I was leaning. I really, and I'm not saying just because it's not broke, we don't need to fix it, but I really haven't gotten any real feelings. There's a strong desire out there to see things change, but so I'd be inclined to table it.
Okay. Attorney Gentis, you had something to say.
I'm realizing too, a lot of the municipal tax sales happen like at town hall, at city hall, and happen all at once now. So those might offer a model. And the primary motivation had to do with the sort of embarrassment, humiliation, similar to the sign issue, that the physical presence of people coming onto your property who had, the weeks leading up to the sale to inspect the property as well and get a sense of what's happening. That's the issue. I'm looking to relieve homeowners of that. And given that we're an unusual state in conducting things that way, that's the motivation. And then perhaps there's some efficiency gains. Perhaps we could use that opportunity, putting aside my feelings-based stuff around it. You could, use an opportunity to make the committees a little more professional than they are now. Perhaps if there's some outliers or some folks who could, having trouble with the single property model, you could create some efficiencies just by having multiple auctions at the same time. It was an idea to, and just knowing that, 48 other states are pulling it off, figuring that there might be a way for us to do it too.
Right. Anyone else?
Again, I said it last meeting, while my heart is with Attorney Gentis's points, when I was even a private attorney, I was involved in foreclosure sales in Rhode Island and New York, which were, the New York was at the courthouse model. But I don't think there's really anything for us to do at the present moment as a committee right here until and if Judge Bellis does refer it back to us when she's dealing with that other issue. But I think right now, I don't think there's a consensus to really move anything. I do think we should table it until Judge Bellis, if she does refer it back to us.
All right. So I'm now hearing, but I would join on the side of the folks that think it should be tabled for the time being. I'd like to hear, I'm now hearing, it seems like that's where at least the people that have spoken, we have Attorney Gentis, sounds like he's on the side of not tabling it. The other folks that have spoken are on the side of tabling it. Technically, if we were following Robert's rules, one motion to table would be sufficient and it would be no discussion, but I don't want to do it that way. So I'd like to just ask how many people think it makes sense to put it on the side burner for now and until something else comes along? Okay, it looks like, I'm sorry, Jeff, looks like you're the sole voice on the other side. So we'll leave it on there because it's certainly something worthwhile to consider. This just may not be the right time, and there's a whole lot of things that go into it. It's certainly, even if we made a recommendation, it's not something that would happen overnight. There are those logistics that we'd have to build into it. So I'll ask Becky to keep it on there as tabled. You will see it under old business. That doesn't mean that we have to talk about it every meeting unless there's something to talk about. It will stay there. It will stay tabled. If somebody makes a motion to untable it, then we can talk about it. But I don't want to leave it off the agenda because I don't want it to get lost. Does anyone have any problem with that approach? All right. Thank you.
And for what it's worth, I'm happy to if liaise with somebody in judicial at your direction or not in the future, if it helps to understand if this is like, if there's certain parts that make this a total deal breaker, or, you know, there's an impasse that can't be solved, so that we don't waste our collective time, you know, pursuing a specific recommendation about, like, say, courthouse steps or something like that.
And I appreciate that. I think the vision that would be held by the people that are higher than we are would be to have the committee as a unit be the ones that would be communicating, as opposed to having one of our members be the liaison. And I know that they would, if it gets to that point too, they'll also reach out to the judges. But so for now, we'll leave it there. And when you see it on the agenda, just know that that's the reason why it's there, and it will show that it's tabled. All right, that takes us to the next committee, or the next old business, which was the committee fee rates. And I think Judge Altermat, you were the one that raised this one. Is that right? That there are different rates being charged throughout the state, and you had looked at some various rates?
I've probably spoken too much about it already the last couple of meetings. I just was more for education for myself than anything else. I was just trying to get a feel for what I think there is a variance across the state, but I think each judge who does it is probably handling it quite well and has some continuity in his or her own district. You know, I'm just trying to.
Thank you, Judge Spader.
I just smooth things out a little bit out where I am, just so I pay all committees the same hourly rate, and I sort of expect roughly the same number of hours to be expended in the task, unless there's something out of the ordinary, which I want to hear about. But I don't think my numbers, there's no magic to it. I'm sure every other judge does the same thing. So I was just, as far as I'm concerned, we've discussed that. I mean, I see in the minutes that there was some discussion that maybe Judge Bellis might want to reach out and get a consensus from across the state, but I'm not even sure that's necessary. I mean, if Stanford is paying their attorneys a bit more than they are here in Putnam, that wouldn't shock me. And, you know, it may be appropriate. So I really, I guess I don't really have an axe to grind on that one.
I appreciate that. And I think what you're referring to is the last section of the minutes, which indicate that Becky had suggested that if there's a recommendation, that it perhaps be that Judge Bellis conduct a poll to determine what the request is, and that could be shared with the committee. She noted the court operations wouldn't poll the judges and their practices without input from Judge Bellis, so that way, and Judge Spader had suggested that we wait till I was back this meeting to talk about it. So, you know, I think your comments, Judge Altermat, regarding the different districts and the rates is fair. I know that Stanford rates are far higher than Hartford too. And sometimes when we have Stanford lawyers come into Hartford and they're trying to charge a Stanford rate, they don't get it here. So I don't know. I guess the question is is there a feeling about the suggestion? I do think that Becky's suggestion that if we are going to recommend anything, it'd be to get a poll. But the question is then, what would the purpose of that be? So I throw it out to folks to tell me if you think it's something that we should be making a recommendation on or not. And if you do, what the intent is once we get that information. Sorry for the two-part question. I guess the first question is whether or not we should make a recommendation of any sort.
From my perspective, I don't think it's necessary. I'm a bit of an information addict, and I don't think it's ever bad to have more information, but you have to take into account who you're asking and how much effort you're asking them to put in for something that may not have a whole lot of value. In an ideal world, it'd be information we had easily accessible at our fingertips and incorporated into the form as discussed at the last meeting. But from my perspective, it's useful information, but I also think that it's also something that one of the judges who had questions could reach out to a peer in another district and deal with informally, as opposed to formalizing it in the forms.
Right, thank you, James. Anyone else? All right, well, let me ask this way then. How many people think that there is not a need for us to make a recommendation on this? George, is your hand up or no? I couldn't tell. I saw a blur. And Maria, did you weigh in? Okay, looks like that's unanimous. So we will leave that one alone. And that concludes our discussion on the committee fees. All right, now for new business, we have defaults after publication. And this one arose, I think, George, that you might have raised this one. It's the way it's worded may not make sense, but when there is a motion for no further notice that is granted by the courts, and then the default comes in after that. I know that we had an issue here in Hartford, which I think has been resolved because there may have been not full understanding that when there's no need for further notice, that the default shouldn't be denied when it's screened through the clerk's office because there was no notice. And this is usually where there's unknown errors, et cetera. So I think, George, were you the one that raised this one, or was it me?
I don't recall raising this, so
All right, it might have been me.
But
It might have been me. So I do have a note here for how we are handling it in Hartford. And let me just hold on. Too many papers. But basically, the clerks are aware here that where there is a default motion for default filed after the motion for order of no further notice, that those have to be, you have to look at those and recognize that means that the notice is not required, so you shouldn't be then denying it. What has been happening is we're getting a lot of motions to re-argue because the judge doesn't see that first line of the motions for default. They're screened through the clerk's office. And there was, some of the folks who are in the front lines spoke to another court to see how they were handling it. And the suggestion was made that the attorneys file their motion for order of no further notice and the motion for default at the same time or in tandem. And so that would be something that I just wanted to throw out to you folks to see how you feel about asking that whether a recommendation should be made to that effect, so, or some notice to make sure that all the various clerks' offices are aware, or if it's even still an issue. So does that make any sense? I know I was kind of threw that all out there.
the only problem I see with that, Your Honor, is generally the reason they're not filed at the same time is because there are other defendants in the case. So to more expeditiously handle the defaults, we generally will file a default for failure to appear as to all of the non-appearing defendants at the same time. However, we will wait until the motion for finding of actual notice is granted before we do that, because obviously if we file a default before the motion for finding is filed, it's going to be denied. So we generally file them all at once for all non-appearing defendants. I mean, if there is a requirement, we can certainly file one default with the non-appearing defendant that was published as to, and then file a separate default for all of the other defendants. But the reason that generally doesn't happen is because the default is filed as to all non-appearing parties at the same time.
All right, anyone else want to, I mean, I get that, although there's nothing that would preclude you from seeking the default against the party for whom you didn't have to provide further notice on, you know what I mean? So I just want to see.
We just generally would file, and this is probably to avoid this exact situation, we would file the motion for finding first and wait for the court to grant that motion before filing the default, because on the off chance that someone sees the default before they see the motion for finding, they may just deny the default, saying that there hasn't been a finding for no further notice necessary.
So let me just tell you this because, and this is why I put this on there. This was the suggestion that came in, and I perhaps didn't articulate it well, but the folks here had indicated that they had spoken with another court who said, and I don't know which court, I apologize, maybe the practitioners know, they often see attorneys combining the motion that no further notice is necessary and the motion for default be granted into one motion so that the court can address it all at once, obviating the need for the separate motion for default. And I was asked to bring this to the committee. Is this something that you could give consideration to at your next foreclosure committee meeting?
Your Honor,
Yes.
from a clerk's perspective, I would have concerns with that just because there are certain notice requirements on defaults for failure to appear that the clerk has to comply with, including sending notice to the non-appearing party. We do that through the JDNO. It also muddies up the record, if you will, and in trying to see where the default is. So I do think it's a training issue from my standpoint that we could certainly reinforce with the clerks. Because I don't know if the expectation, even if you were to file separately your motion for their finding and your motion for default, the defaults don't calendar on the short calendar, the foreclosure calendar either.
Right, that's
because
the
they
problem.
are, clerks handle those. So is the expectation then that the foreclosure judges would do the further finding unnecessary and the
Right.
default?
So
or
apparently the
direct-
courts that are doing it or are accepting them is, as I just read to you, they often see the attorneys combining the motion for no further notice is necessary and the motion for default in one so that the court can address them all at once. So it would be just like the clerks know, if it's something that goes beyond just a simple default, they are supposed to send it to the judge. There are courts doing this. I don't know which ones, I didn't ask, but the clerks did reach out and indicated that is being done in some courts. And certainly it wouldn't be granted if somebody were seeking a default for all parties. I think what I'm reading from what was sent to me is that it is where the person is seeking the motion for no further order of notice, they're asking for the default as to that defendant. So it is, just so you're aware, I know you said you'd have some concerns for the clerks. You should be aware some of the clerks this is already being done in some courts.
Absolutely.
But I do like the idea of it being a training issue. And so that may obviate things. So pipe up, folks. What do you think?
I can
Your
only
Honor,
speak to our office. Oh, sorry, go ahead, James.
this is one of those things that comes up every 3 or 4 years in a different courthouse each time, like between defaults for failure to appear after publication being rejected due to improper certification, which how you say it was improper certification when it was serviced by publication because we don't know where to find the person to send them mail. Or I cannot tell you how many times over the years I've seen, generally it's a generational shift, newer group attacks, etc., where a default for failure to plead is denied because something got filed, but not an actual order of pleadings per the practice book, like a mediation petition or a motion for stay. And then there's a talk to the chief clerk issue about they need to, can you retrain them that a default plead is about a specific list of pleadings, not just any filing by a defendant, et cetera, et cetera. There are a handful of these issues that come up every couple of years, usually in a different courthouse. From my perspective, this is one of them. I can say, as the person that reviews my office's new templates and whatnot, I have not seen or been asked to approve, which tells me shouldn't be being filed by my office, a composite, what we call a MIFNU, motion for finding no further notice, and default all in one motion. Our case management system prompts those to be filed simultaneously, or at least drafted simultaneously, but not in one document. So I'm not sure what courthouse is doing them, and I'm also not sure which practitioners are doing them, because if it's not George's office and it's not my office, then it may be few and far between, and it is what it is. But I don't think this is a issue where the committee really needs to make a recommendation. I think this is a periodic training issue for the various, the applicable clerk's office.
All right. Anyone else have anything to say?
That's
how many
basically
people agree
exactly what I
with?
was going to say. I know that our office does not file them as one motion, so if it's not us and it's not Attorney Bucklandon's office, it must be some smaller firm that's handling foreclosure actions and must have a lot of cases in one specific courthouse. And I think that may be why that one particular court is seeing that. But I personally have never seen a motion like that. I know that our motions for finding of no further notice do specifically state that the defendant has not appeared, but it's not an actual motion for default for failure to appear that's in the motion for finding of actual notice.
Yeah, I haven't seen it either here, which is obviously why we had issues here with something's happening. So I knew that, but I don't know. Maybe it's Putnam. Hold on just a moment, folks. I just want to see if they're telling me my jury is back. Okay, folks, so my jury is back, but my monitor and my clerk are not. So I have about 10 minutes, which I think is good. I think we can get through this. Is there anybody who has an opinion other than that this is a training issue for the clerks? All right, and then that's great. It looks like nobody's raising their hand. So Becky, is that something that we need to make a recommendation that it be included in training, or is the fact that the committee's discussed it and told you sufficient?
That is sufficient, Your Honor.
All right. All right. And motions to open?
Your Honor, this was in relation to motions to open that are filed upon alleged consent without giving the opportunity
Oh, yes.
to be heard.
Thank you. Thank you for refreshing my recollection. So, and this one I think might have been raised by either Attorney Pocklington or Attorney Generous.
This one was me.
All right. So do you want to give like a quick Reader's Digest summary?
I just raised the issue at our last meeting of the fact that we had been seeing an increasing number of defendants' motions to open filed with the court, either with or without a case flow request. Generally, the case flow request would indicate our office had consented to the relief requested in the case flow request, generally the motion being heard immediately, when in fact the defendant had not even contacted our office to get consent. And then the motions were being granted basically the same day they were filed without giving us a chance to file any opposition to the motion or request a hearing, whatever the case may be. So that was the main issue that we were having. It had been more common within the last few months, so that's the reason that it was raised at the last meeting.
And it's a legitimate concern. And I think that the parties that are in foreclosure court a lot know that both in Hartford and I know that both Judge Spader and I did this in New Haven. If a case flow request comes in, there's sort of I won't call it, it's not an official order, but if it comes in and it's an emergency that comes in late, then with a case flow request, the court, generally will act on it. If the sale day is the next day and it comes in on a Friday with a case flow request. However, it has been the practice, I believe, in both courts. I know it has been mine, and I believe it's been Judge Spader's. The clerk will reach out because it is unclear whether, a lot of times they're self-represented parties and they don't even really know sometimes what the consent checkbox means. So the clerk's office will simply reach out to make sure that plaintiff's counsel has received a copy and is aware of it. If there's any time, what we ordinarily do is it'll either be marked take papers for the next short calendar, which gives the other side or whoever else may be involved an opportunity to be heard, or it's not ruled on immediately if it's not that emergency situation that just before the sale. For that very reason, it's not fair to not let both sides be heard. Now, with the plaintiff's motion to open, quite frankly, those are not an issue generally because they inure to the benefit of the defendant if they're seeking to extend a sale date. So I just would like to hear from you folks. It seems to me that this again might be something to ask Becky to just include in her training session with the clerks, that if they get a motion to open, or maybe the judges need to know too, but if they get a motion to open that's filed in the 11th hour, that's not an emergency motion and that indicates consent, there needs to be some cooling off time to allow the other side an opportunity to determine if they're going to object or not. Thoughts?
One thing that strikes me, Your Honor, my office was just contacted by a clerk at a court that we used to work with fairly regularly in the physical appearance days with hey, who in your office should I be sending? We've got a motion. It was literally this scenario. It was a motion to open and wanted to get our position on it. Who in your office should I be sending that to? I don't know whether it would make sense for there to be some, whether official or unofficial branch maintained list for because let's be honest about it, the foreclosure space on the plaintiff side of things is relatively small between the couple of big firms and then the local practitioners that are known well in their districts.
Hold on, folks. I'm sorry, but I think they're calling to tell me I have to go in. Sorry, folks, I've got 5 minutes and then I'm going to have to depart. So your suggestion, James, was?
Just, it might make sense for there to be some, just a smidge of bureaucracy and a list maintained that can be distributed to the various clerks, much like they have a list of what marshals are on, the day list for marshals, who's going to be coming in to accept service or to help individuals with service of things. Maybe a list of the appropriate contacts at the large plaintiff firms or the plaintiff firms in a particular district could be circulated by the branch, so that when a clerk has a question like this, they know who to reach out to, and then make it our problem to make sure that that's the most recent updated and correct information. Just try and streamline some communication.
Okay. Anyone else? Becky, anything?
Your Honor, I think that it would be helpful if it were a formal recommendation, much like this committee did the recommendation for joining, like the clerk joining, 15 minutes in advance wherever possible. Okay. For the, it just leads, I think it lends it a little bit more of a procedure and a history. I absolutely can tell the clerks that they have to reach out. I appreciate Attorney Pocklington maintaining a list, but I have concerns about the smaller firms too. Whatever we're doing, we should be doing across the board. So whether or not it makes sense to reach out to the attorney of record on the file and leave a message or an email. I mean, that's something that maybe clerks don't do so frequently, but caseflow does that regularly. Right. So I don't have concerns about that. That's something like mediators do stuff like that regularly. So whether it's the clerk or it's probably most likely going to be a combination of caseflow with the clerk, because caseflow would get the caseflow request and probably notify the foreclosure clerk in any JD. So I don't think that would be an issue.
All right, so let me ask this, and if you are on board with this, then I would entertain a motion. How do folks feel about that idea of making the recommendation consistent with what we just discussed, that if a caseflow request is filed by a self-represented party with limited time, that the clerks confirm that the opposing party has received notice and doesn't send it to be acted on immediately absent emergency situations? And if that's, let me ask you that, and then Becky and I can put something together if you're all on board.
So moved.
I like that, and just to
okay, thank you.
I would suggest make a reasonable effort. That way, there's no, I couldn't get someone from the bank's attorney's office on the phone, so I didn't send it on the judge, or didn't send it on to the judge, confusing.
They usually send those immediately anyway, so I don't think that's a concern. So we have a motion. Is there a second?
Second.
All right. So we have, I don't know whose hand went up first, either Tage or James, one of you. All right. Any further discussion? All those in favor signify by saying aye.
Aye.
All right. Thank you, everybody. It carries. Now, under other business, I just wanted to let you know that we did receive a letter of resignation from Attorney Sternberg. She has changed firms, and so she sent notice to Becky to let her know she's no longer handling any foreclosure. She sent a letter of resignation to me, which I will have circulated to you folks if you'd like. It just says, Judge Baio, please accept my resignation from the Bench Bar Foreclosure Committee. I've enjoyed my tenure over the past decade, but find that I'm no longer handling foreclosure work in my current practice. Thank you for your efforts with the committee, which does such important work. Very truly yours, Jenna Sternberg. So that resignation has been tendered and is accepted, unfortunately. But we do have 2 wonderful new additions to our committee. And folks, I hope there's no other business because I have to go take a jury verdict. All right, I'll entertain a motion to adjourn.
So moved.
Somebody. Second, anyone? All in
Second.
favor?
Second.
All right, great. We'll see everybody. You'll get emails in the interim, and our next meeting is October 29th. Have a great rest of your day, everyone. Thank you very much.
Thank you,
Everyone.
everyone.
Bye.